An incarcerated individual at Dallas County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number.
To accept this free call, press 1. To refuse this free call, press 2. If you would like to, thank you for using Securus. You may start the conversation now.
Hello?
Hello? Yes?
Yes, can you hear me?
Yes, I can.
Okay, we live. I'm frozen on the screen, but we live, so I'm not gonna even stop it. Could you identify your first and last name and felony case number as well as your appealing attorney?
Okay. My name is Omni Williams. My felony case number is F2221231. And my felony attorney is Matthew Seymour.
All right, I have this question. Have Matthew Seymour appraised you on what to expect on the March the 21st, 2024 evidentiary hearing on your motion for new trial?
No, not at all.
At this time, what would you like to ask Matthew Seymour?
Well, I just want to ask him, Mr. Seymour, I do have a question for you. Mr. Simmons said that you're not going to submit my motion for new trial and attach affidavit into evidence at the hearing, and I want to understand why that is.
Oh.
I also wanted to ask.
Go ahead.
I'm sorry, I had another question. I just wanted to ask him, why would he tell my sister that I'm going to have a new trial because my court-appointed attorney was ineffective, but I'm still going to go to prison? I don't understand what that means. That seems like.
So let me be clear on something. You saying Matthew Seymour called your sister and told him that they have to give you a new trial, but you're still going to prison.
Yes, you told my sister that.
You got hold up. When you speaking, you're not clear. I don't know what you're doing, but when you're speaking, you're not clear.
Okay. Can you hear me okay?
Yes.
Okay. So, yes, he communicated with my sister and told my sister that because of the fact that the court-appointed attorney did his job improperly, that I'm going to get another trial. But I'm still going to go to prison. And he said that I won't be able to communicate with anyone, excuse me, once I get there for 45 days.
Okay.
I have no idea.
Okay. If you tuning in live on this live, I my screen froze. I modified my Wi-Fi, so I don't know what's going on, but I'm gonna keep the stream going. Let me put some context to this here. I wrote Matthew Seymour today through an email. He wrote me back. Now, I informed her appealing attorney that in order for Omni Williams to be granted the actual new trial based on her motion for new trial, he must offer her sworn motion for new trial along with my sworn affidavit that was filed January the 22nd, 2024 into evidence. Matthew Seymour has advised me that he has two affidavits that he's going to submit into evidence, but neither one of those, in my opinion, are valid enough because they do not familiar with the facts alleged in Omni Williams' motion for new trial. But let me be clear on one thing. I spoke to Matthew Seymour today, Omni Williams, through the email, and I asked him why wasn't he calling me to be a witness, and he basically said I didn't need to be a witness. Now, I also spoke with him through email. He gave me the impression that he is not going to submit your sworn motion as well as my affidavit into evidence. If he failed to do this, the judge would be correct in denying your motion for new trial. He knows this, and I know that. Now, he has stated to me that he has 20 plus years of experience and that you are in good hands. I like to believe that. But let me tell you why I don't trust your appealing attorney. By the way, your appealing attorney has stated that I keep alarming you, but I will let you address that in a few. First of all, Matthew Seymour, we are at this point today because of Omni Williams and myself. When she filed her sworn motion for a new trial on January the 22nd, 2024, with my attached affidavit having full knowledge of the facts in there, the public defender's office, you yourself, Philip Borden, and the trial clerk, as well as the judge, tried to get around that motion for new trial by filing a notice of appeal and backdating it when it didn't exist. And not only that, Philip Borden filed a slash appeal notice of slash motion for new trial, but did not follow it up with any grounds for appeal. This is where you come in at Matthew Seymour. You turned around and filed an amended motion for a new trial, alleging ineffective assistance of counsel. But the problem with your motion is this: how can you allege ineffective assistance of counsel when you did not have the court reporter's record before you to determine that? See, you are basing your motion, your amended motion for new trial, on Omni Williams' original sworn motion for new trial, showing you Philip Borden was ineffective. Now, which is a great thing that you did, but I'm here to show you that it's not nothing because of what you did. It's what Omni Williams and myself have done. See, you have been forced to represent her, but at the same time, I believe that you are trying to sabotage the actual hearing, the actual motion for a new trial being granted, because you are refusing to enter her sworn motion for new trial into evidence, as well as my sworn affidavit. You must enter those documents into evidence in order for her to get a reversal, unless the judge simply deem them not necessary. But according to the law, they are necessary. Now, Omni Williams, what would you like to kind of ask Matthew Seymour going forward? Now, let me ask you this here. You also have a pre-trial hearing on March the 21st at 9 a.m. Do you know what that's about? Have Mr. Seymour reached out to you?
No.
I didn't hear you.
No, I haven't talked to Mr. Seymour at all in over a month, so I have no idea what the pre-trial hearing is for, or neither did he brief me or prepare me or make any type of preparation for me for the evidentiary hearing. I don't even understand why we would have a pre-trial hearing and an evidentiary hearing on the exact same day.
Well, I'm going to tell you what I think is going to happen. Now, I'm just theorizing. I don't know now. Since Matthew Seymour refused to appraise you of what's going on, here's what I think is going to go on. You have two hearings, but you didn't know nothing about the pretrial till I told you. Now, they have a pretrial hearing on the same day at 9 a.m., and they have a motion, the evidentiary hearing on a motion for new trial at 1:30. Here's what I think. I'm not sure. I'm just thinking because myself, I don't know why they having it. I believe that the pretrial hearing, that's when they're going to determine. I'm not going to, I just think, I don't know, so I'm not going to speak to that, to be honest with you, because I just don't want to state something that I really can't. I just don't know why they having it. I got a theory, but I don't want to express that theory. You understand? Okay, so I talked to Matthew Seymour. He said you in good hands. He said he got a game plan, so we're going to wait and see how that play out. But I'm standing firm on this here. The affidavits of, I believe, Roger Smokes and Frank Douglas, I believe that's it. Those are two affidavits. You can enter those affidavits as evidence, but as far as those affidavits burn on the facts of ineffective assistance of counsel as spelled out in Omni Williams' motion, they would be insufficient to support it. My affidavit that was attached to her sworn motion for new trial is the only valid affidavit to that can testify, because I uploaded and I collected that evidence. And this is something I believe that you are trying to get around, because Philip Barton never intended for Omni Williams to have a valid grounds for appeal. This is why he never preserved any error. Initially, when you, Mr. Matthew Seymour, was trying to perfect this appeal based on the trial record, you already knew that the appeal would be affirmed based on the trial record itself, because Philip Barton never preserved any error. When the Court of Appeals look at the trial record prior to expanding the record on appeal, as you are attempting to do coming this March the 21st, 2024, the court would have looked at that record and say that there are no errors. It is silent as to ineffective assistance of counsel. You cannot prove ineffective assistance of counsel on direct appeal unless you expand the record for appeal with a motion for new trial. And this is what Omni Williams and myself have done. Now, Omni Williams is contending that if she is given a fair trial where an attorney would test the prosecution case, a not guilty verdict is a guaranteed verdict, and I do agree. Now, Omni Williams, would you like to address to your attorney, Mr. Seymour, how how Philip Barton was ineffective from beginning to the end of your criminal case?
Yes, I would.
Go ahead.
Okay. So initially, Philip Barton got my case in October of 2022. I did not hear from him nor see him until March 16th of 2023. On that day, I saw him. The next time that I spoke to that man or saw him was June 27th of 2023. That's when he offered me 15 years. I told him I wasn't going to take 15 years for something that I didn't do. He said, okay, I got to bring you back to court again next week. I came back to court again on July 3rd of 2023. At that time, Philip Barton and the judge, which is Judge Tracy Holmes, asked me, was I going to take 15 years? I told them absolutely not. I will not take 15 years for something that I did not do. So they said, okay, we're going to have to set you for trial. After that, which was July 3rd of 2023, I did not see Philip Barton again until January of 2024. So I decided to call him in November 2nd of 2023. Our conversation, I asked him, why did he not file any of my motions? I asked him, why didn't he show me any of the statements or any of the evidence that they had against me? I asked him, why have I been in jail for over a year as an innocent person? He told me that there were a lot of people that had been in jail for over a year that were innocent people, and he hung up in my face. But before hanging up in my face, he completely refused to show me the evidence and the statements against me. He told me that I was not allowed to see all the evidence that was against me, which is a lie. I have the right to see what they're alleging against me. With that being said, Philip Barton refused to procure any of my witnesses. He did not file any of my motions. He did not do any type of an investigation. He didn't even receive the discovery, which he said to me that he saw the discovery for the first time on January 11th of 2024, which he had no time to prepare any type of defense as our trial began on January 16th of 2024.
Okay, let me say this, Omni. Let me say this, Omni. Matthew Seymour is well aware of your sworn motion for new trial, directing the trial court attention to Philip Barton on my YouTube station, Speak Van Holden 247. He is well aware, the judge, they are all well aware of the evidence where I have preserved for you on my YouTube station, where Philip Barton denied knowing me, denied me telling him I'm a witness. He also pretended that he had witnesses for you, but didn't put any witnesses on. He also stated clearly that he never received my email with your written letters instructing him what he needs to be doing for you. So, like I said, I spoke to Matthew Seymour today through the email. He has made it clear to me that you are in good hands. And but once again, I'm gonna say it like this here. I don't trust him because initially Matthew Seymour tried to circumvent your motion for new trial and perfect your appeal based on the trial record, in which we already went on the record on the YouTube station letting him know that if he proceed with an appeal, it's going to be affirmed because there is nothing in the trial court record that Philip Barton preserved that has a merit issue to be raised on appeal. Now, going forward with this motion for new trial hearing, if Mr. Seymour do his job, bring up your sworn motion, because your sworn motion clearly directs the trial court to the evidence to support your allegations. So even and this is why Mr. Seymour must admit that your sworn motion for new trial into evidence along with your attached sworn affidavit from me. So if he does not submit this into evidence at that hearing and the judge deny your motion for new trial, that will be one of your main reasons that you can take up on appeal that your attorney. See, here's the problem. Matthew Seymour is your appeal attorney. If he is ineffective at the evidentiary hearing for motion for new trial, he's not going to raise that on appeal. That will be something that you have to attack on a writ of habeas corpus. And like I stated, according to your sister, Matthew Seymour called your sister and told them that they have to give you a new trial, but you're going to go to prison. So what I think that meant is that they're going to deny your motion for new trial, send you to prison, take it up on appeal, then it's granted then. That's just the only thing I can see, because I don't know why Matthew Seymour, your attorney, will be calling your sister and telling her that. I don't see the reason for that. So going forward, I spoke with Matthew Seymour. Like I said, I don't trust you, Mr. Seymour, because Patrick Crawford filed a notice of appeal, and then Philip Barton, and they did not exist. The problem is, if Philip Barton filed a notice of appeal and a motion for new trial, and it was valid, are you telling me that Philip Barton filed a motion for new trial with the intention of telling the court that he was ineffective? Because that's the whole basis of her sworn motion for a new trial, as well as your amended motion for new trial, Mr. Seymour. So there's a problem there. And I'm contending, and Omni Williams already know, the initial motion / motion for new trial that Philip Barton filed was to try to interfere with a valid motion for new trial. So we're just going to have to wait and see how this play out on March the 21st, because Omni Williams and myself, we really don't know what the pretrial hearing is for on 9 a.m., but we understand the 1:30 evidentiary hearing on a motion for new trial. So now, Omni Williams, Matthew Seymour said last week on a Thursday he mailed you some documents. Have you received anything from him?
No, I have not.
Okay. So he said he mailed it Thursday. Let's say he mailed it Thursday, went out Friday and Saturday. Today is Tuesday. You should have got it today, at least by Monday. So we confirmed that you haven't got that. But he did, Matthew Seymour did acknowledge that he received a call from you from my number. So we'll just wait and see. The only thing we can do now is wait and see. But I have informed Matthew Seymour the failure to offer your sworn motion for new trial into evidence, as well as my sworn affidavit attached to your motion for new trial, that would constitute ineffective assistance of counsel. And by the way, Matthew Seymour, I don't have to be an attorney. I don't have to be an attorney. Everything I'm telling you is correct, and you can't refute it. This is why we are where we at today, Mr. Seymour. So, Mr. Seymour, before you go, Omni Williams, thank you for being on. I'm going to close it out, and give me a call tomorrow about 12 noon.
Yes, sir. Thank you so much.
You're welcome. Now, Mr. Seymour, let me tell you something. I'm going to respect your wishes, but I'm going to tell you something. Philip Barton was appointed to be Omni Williams' attorney. He has what y'all call a bar license, whatever you want to call it. He's supposed to be highly trained. But look what he did. From start to finish, he deprived her of effective assistance of counsel from the beginning of appointment to all the way up to the ending of being sentenced. He did no investigation. He helped the prosecutor convict her. So why would anybody have faith in a public defender's office in Dallas County? Why? When you initially filed a notice of appeal or designating the record, you clearly stated in the record that no motion for new trial was filed until I chimed in. So how are you going to say no motion for new trial has been filed when you clearly see that it has been? See, this was your attempt to get around it, because you know, just like I know, if we take away the motion for new trial and file appeal based on the record, we all know that the trial court judgment would be affirmed, because there's nothing in the record to show an error worth raising by Omni Williams. We know that. See, I don't have to have a legal degree to know this here. There is nothing in the law that say you have, but if I have enough knowledge to know when this attorney done violated his right, Omni Williams' right to effective assistance of counsel, you don't need no law degree. Come on now. You think what attorney in their right mind will file a claim of ineffective assistance of counsel against themselves? This is where the individual must now understand and know the law to bring those type of claims. So it's going to be interesting to see how this play out, Mr. Seymour, because remember, your sworn motion for new trial does not have affidavits attached to it. They came late. Roger Smoltz and Frank Douglas affidavits are not attached. So what are they testifying to? They just testifying to the fact that he should have did this, he should have did this. That's fine. But they can't testify to the facts that he completely denied her effective assistance of counsel based on her sworn motion, unless they go review those videos and see it for themselves. Anybody can see that. So let's get this case overturned and let's set it for trial. You know, she has a constitutional right to a fair trial. So how can a trial be fair where the attorney is not putting on the defense, but just holding the defendant's hand down the lane to get her head chopped off? Anybody can do that. That's what you do to pigs at the slaughterhouse. And so we all understand that the trial was constitutionally infirm. Okay, so we all understand that the facts and the evidence indicates that the trial judge, as a matter of law, must and should grant a new trial. The trial judge will abuse her discretion based on the evidence outlining Omni Williams' sworn motion for new trial. So I'm going to end this live and update the message, and I'm going to let you know, inform you, Matthew Seymour, get on your business.